I'm Dr. Mansoor Madani, Chairman, Department of Oral and Maxillofacial Surgery at Capital Health System in Trenton, New Jersey, and Associate Professor of Oral and Maxillofacial Surgery at Temple University in Philadelphia, Pennsylvania. As an oral and maxillofacial surgeon and an integral part of the trauma team, treating patients with a variety of facial injuries for many years, I've taken the task of bringing this sad but important presentation to you in hope of saving lives of children who have been abused, mistreated, or neglected. With guidance from the Pennsylvania Department of Human Services Office of Children, Youth, and Families Bureau of Policy, Program, and Operations Division of Policy, I will be discussing what is required to know about the laws as it applies to child abuse and neglect in the state of Pennsylvania. If you're told by law you must take this course or similar courses like this, it means that you are a mandated reporter. In other words, it also means that you're legally required to report suspicions of abuse or neglect to appropriate authorities, in this case to Child Protective Services. Before I start this presentation, think about a child who is abused and neglected and how you can help to save his or her life. Child abuse and neglect is a difficult and sad subject to think and talk about, but it is one that we must be prepared to address and be vigilant to prevent it. It is hard to imagine anyone harming a child. As disturbing as it can be, child abuse and neglect is very real. We can never imagine and understand why an individual commit abuse and neglect. My goal in this presentation is to discuss and provide you with clear scope on your role as a mandated reporter in recognizing and reporting suspected child abuse cases. Also, meeting your legal as well as ethical obligation in the areas of child protection as per the Child Protective Service Law, or CPSL, in Pennsylvania. I hope that you apply what you learned during this course to recognize elements and indications of child abuse and neglect and proceed to report abused cases in your field and hopefully save a life. At the end of this course, I hope you achieve the following goals and objectives. Understand the important fact and guideline as it relates to the welfare of children in cases of abuse. Identify the infrastructure for protecting children from abuse, recognizing potential signs of abuse and neglect. Identify the expanded legal definition of child abuse based on Pennsylvania Child Protective Services Law. Determine when to report suspected child abuse. Understand the role, rights, and responsibility of mandated and permissive reporters. Please listen to the entire presentation if you would like to receive CE credit for this important course. Please follow the instruction at the end of the course. Upon completing a quiz, you will be directed to a form which will ask you to provide your information, including your name as it appears on your professional Pennsylvania license, your Pennsylvania license number, your date of birth, the last 4 digits of your social security number. Also, please note that upon receiving your completed quiz, we will submit your CA participation electronically to the state. This is the only method accepted by all the state boards. The CE certificate will be for your records only. So, why do we need to learn about Act 31 of 2014? The answer is because there are alarming numbers of cases that have occurred but have not been reported. So to help prevent the growing number of child abuse and neglect cases, every state has passed legislation to increase the reporting of suspected abuse and neglect cases. Under Pennsylvania Child Protective Service laws, several classes of individuals are listed in the state statutes as mandated reporters. Although my dental colleagues are considered mandated reporters in every state, they have done a remarkably poor job living up to that obligation. In fact, dentists reports less than 1% of all abuse cases. But medical professionals surprisingly report less than 50% of cases too. Any mandated reporter must be trained and is required to report cases of abuse and neglect. In fact, as a mandated reporter, you are required under penalty of law per Pennsylvania Child Protective Services to report any child suspect of being abused and neglect that comes under your purview. There are two types of reporters: mandated reporters and permissive reporters. The mandated reporters are required by law to report suspected child abuse and neglect. Anyone who is licensed or certified in many fields, including the health-related field under the jurisdiction of the Department of State, and I will go over the detailed list of them shortly. On the other hand, a permissive reporter, regardless of professional affiliation, can report to appropriate authorities as a concerned neighbor, friend, witness, or bystander. Now let's see who are the mandated reporters. The following individual should report suspected child abuse if they have reasonable cause to suspect that a child is a victim of child abuse or neglect. Professionals such as doctors and social workers. Persons licensed or certified by the state board in any health-related field are of course mandated reporters. Persons such as medical examiner, coroner, funeral director, and emergency responders are explicitly listed as mandated reporters. An employee of the healthcare facility or providers licensed by the Department of Health who are engaged in admission, examination, care, and treatment of individuals. This list also includes school employees. An employee of a child care services who has direct contact with children in the course of employment. A clergyman, priest, rabbi, minister, Christian Science practitioner, religious healer, or spiritual leaders of any regularly established church or other religious organization are all mandated reporters. An individual, paid or unpaid, who, on the basis of the individual's role as an integral part of a regularly scheduled program, activities, or services, is a person responsible for the child's welfare and has direct contact with children, is a mandated reporter. An employee of a social service agency who has direct contact with children in the course of employment. A peace officer or law enforcement officer. An emergency medical service provider certified by the Department of Health. An employee of a public library who has direct contact with children in the course of employment are all mandated reporter. Additionally, an independent contractor, an individual supervised or managed by a person listed under all of the above who has direct contact with children in the course of employment. An attorney affiliated with an agency, institution, organization, or other entity, including a school or regularly established religious organization that is responsible for the care, supervision, guidance, or control of children, is also mandated reporter. A foster parent, and finally an adult family member who is a person responsible for the child's welfare and provides services to a child in a family living home, community home for individual with an intellectual disability, or host home for children which are subject to supervision or licensed by the Department of Health Services or DHS, are mandated reporter. There are 16 listing of mandated reporter based on Pennsylvania child abuse and neglect law. Now let's see what Act 31 of 2014 training is all about. This is the law that affects all Pennsylvania board license holders. It requires the initial training and continuing education in child abuse recognition and reporting. Effective January 1, 2015, all persons applying for issuing of an initial license shall be required to complete 3 hours of DHS-approved training in child abuse recognition and reporting requirement as a condition of licensure or to obtain a license. And I have been discussing this since that time in a variety of form, in person and in previous version of this video presentation. Please remember that for all license renewal, these credit needs to be earned prior to the end of each license cycle date. For example, in the field of dentistry, it is every 2 years and is by March 31st of those years. So it is important to know that all health-related licensees applying for the renewal of license issued by the state board shall be required to complete at least 2 hours of Pennsylvania board-approved continuing education in child abuse recognition and reporting requirement as a condition of renewal of their license. For all licensees, renewal, this credit needs to be earned prior to the end of each license cycle date as stated above. In order to properly comply with the legal mandate for all health professionals to report suspected case of child maltreatment, doctors, dentists, and affiliated professionals must be aware of their responsibilities. So as a mandated healthcare professional, we are supposed to do the following. First, we must examine and document our observation of any suspicious evidence that can be obtained in the office or the hospital. Carefully record any evidence that may be helpful in the case, including physical evidence and any comments from questioning or interviewing the person. Importantly, to treat any injuries, this is really important, to treat any injury within the treatment expertise or scope of your practice. However, if more extensive treatment needed beyond your expertise, refer the individual to a hospital or to a specialist. Let me stress that you must treat the patient and do not delay urgent treatment that could harm the patient even more. At the same time, it is also imperative to establish and maintain a professional therapeutic relationship with the family. Finally, report your finding or suspicion of abuse or neglect to appropriate agency and assist law enforcement. A question that for years I have asked my audience when I was giving these lectures in person is, as a mandated reporter, have you ever reported a case? Luckily, with the training like this, many dental and even other professionals that attended my courses have replied in favor of that question. Another question is, if you have ever thought that a patient was abused by their caregiver, do you know what to do, where to call, and when to call? Unfortunately, as I mentioned before, even medical professionals fail to report half of mistreated children they see. Remember, it is the law, but it is also the right thing to do. To properly comply with the legal mandate for all health professionals to report suspected cases of child maltreatment, doctors, dentists, and affiliated professionals must be aware of their responsibility. And that's why I have diligently created this presentation. And if with your help we can save a child's life, then we have achieved an important goal. Now let's begin with a scenario. Unfortunately, I see many patients in the hospital emergency room with major facial trauma, and the hospital has a very strict response reporting policy. That's the sort of policy we need to have in everyone's offices too. Think about a case like this in your office. An 11-year-old boy comes in to your practice with bilateral injury and laceration on his face, bleeding from his nose and mouth, bruising around both eyes. His mother claims that he fell when he was playing at home. But he tells you a different story with hesitation. It seems that he is reluctant to tell the truth, considering multiple sites of injury. You don't believe the mother's story. What do you do? Here are a couple of questions that I like to ask. What should you do? You may say, I'm not a surgeon and I have no idea what to do. It may get better by itself. Or you may have a financial concern and say, I'm not exactly sure what to do because the family also brings their children to me and I may lose their confidence and these patients. But the correct and decisive answer is that I know exactly what to do according to Pennsylvania law. Now you can easily answer this question. In this scenario, you are a mandated or permissive reporter. Of course, the answer is you are mandated to report your suspicion. And I'll explain later, you only need reasonable cause to report child abuse. So file a report of suspected child abuse to Childline. The children welfare system in the United States is established like this. The federal government and the Congress develop laws and provides funding to the states. State legislatures develop state laws in accordance with federal legislation and provide fundings. Department of Human Services develop regulations to implement state laws, distribute fund and establish registry. County agency and commissioners hire county children and youth directors and provide additional funding. County children and youth services agencies provide protective services for children and are responsible to investigate the suspected abuse and assess the need for general protective services or GPS. Department of Health Services regional offices monitors all county agencies. The DHS or Department of Health Services Childline receives the report of child abuse and registers the report and additionally provides clearance when indicated. In Pennsylvania, the state oversees the county's implementation of child welfare services. Remember, the 24/7 hotline to call or register a report in Pennsylvania is done online at www.compass.state.pa.us state.pa.us/CWIS or by calling 1-800-932-0313. Pennsylvania child welfare system is a state supervised and county administered system. The county children and youth agencies have two main functions. The first function is Child Protective Services or CPS for suspected child abuse cases which requires a child abuse investigation. The second function is known as General Protective Services or GPS, which is for non-abused cases, and they assess any need for services in non-abused cases. Please remember to always report suspected harm to a child. It is not your job to decide who reviews this case. And I will repeat this again during the presentation. That is your job to simply report a case. Functions of the County Agency for Child Protective Services, or CPS, are listed below. CPS handles services or activities provided by the Department of Human Services and each county agency for child abuse. They receive reports, investigated, making sure the children are well protected and taken care of during the investigation. They also determine the status of the report of suspected child abuse. The Pennsylvania Child Protective Services Law was established in 1975 to protect children from abuse and allow the opportunity for healthy growth and development of children, while at the same time preserve as well as stabilize the families wherever possible. The Pennsylvania Child Protective Services Law does not restrict the generally recognized as existing rights of parents to use reasonable supervision and control when raising their children. There have been few recent amendments to Pennsylvania Child Protective Services Law relevant to child abuse recognition and reporting. First one is Act 115 of 2016, and that's related to human trafficking. The second one is Act 88 of 2019, which is related to penalties for failure to report or refer. Cases identified as CPS requires an investigation because the alleged act or failure to act meet the definition of child abuse. The Pennsylvania Child Protective Services recognizes 10 separate categories of child abuse. This is really important. Examples of child protective services cases are causing bodily injury to a child through any reason or failure to act, causing sexual abuse or exploitation of a child through any act or failure to act, causing a reasonable likelihood of bodily injury to a child through any recent act or failure to act, creating a likelihood of sexual abuse or exploitation of a child through any recent act or failure to act, fabricating, feigning, or intentionally exaggerating or inducing a medical symptoms or disease which result in a potentially harmful medical evaluation or treatment to the child through any recent act, causing substantially contributing to serious medical injury to a child through any act or failure to act or a series of such act or failures to act, causing serious physical neglect of a child, engaging in a specific reason per se act, which is Latin for by itself. In other words, inherently act of abuse, causing the death of a child through any act or failure to act, engaging a child in a severe form of trafficking in person or sex trafficking. The county agency is the sole civil agency responsible for receiving and investigating reports of child abuse except report of abuse allegedly perpetrated by an agent. The county agency shall investigate allegation of abuse of children residing in facilities operated directly by the department. The county agency shall protect the safety of the subject child and other children in the home or facilities and shall provide or arrange appropriate services when necessary during the investigation period. The county agency shall determine the status of the report of suspected child abuse. If the county agency concludes that a child is in danger of further child abuse, the county agency shall do the following: accept the case for services, provide direct case management, monitor the provision of services, whether provided directly by the county agency or through purchases or agreement. The county agency shall provide direct case management of services provided to abused children and their families until the county agency is reasonably assured that the child is no longer in danger of child abuse. The reason for termination of county agency involvement shall be recorded in the case record. Functions of County Agency for General Protective Services, or GPS. The Pennsylvania Code website reflects the Pennsylvania Code changes effective through 53 PAB number 3392 dated on June 24, 2023. As I explained earlier, General Protective Services cover non-abuse cases. In these cases, the alleged act or failure to act may not meet the definition of child abuse, but is still detrimental to a child. The primary purpose is to protect the right and welfare of the children so they have an opportunity for healthy growth and development. Example of GPS cases include services to prevent the potential for harm to a child who meets one of the following conditions. The child is without proper parental care or control or education as required by law, or other care or control necessary for their physical, mental, or emotional health or morals. The child has been placed for care or adoption in violation of the law, or the child has been abandoned by their parents, guardian, or their custodians. Protecting children from abuse and neglect is a community responsibility. We all need to put all our effort together in reporting. Report to Childline. Go online at, as I said, www.compass.state.us CWIS or 1-800-932-0313. So what are the key components of child abuse? When talking about act or failure to act, this refers to an act of said abuse or failure to act upon preventing the harmful situation from happening to a child who is younger than 18 years of age. The law considers both an act of harm to a child and the failure to act to prevent harm to a child when defining an act of child abuse. Then an act is something that is done to harm or cause potential harm to a child, and the failure to act is something that is not done to prevent harm or potential harm to a child. The final component is the recent act, which is any act committed within the 2 years of the date of the report to the Department of Health Services or the county agency. Remember, act and failure to act have no limit, but recent act has 2-year limit. Let me just be clear about this. The law begins with 3 words to discuss component of child abuse, and that is simple and clear: intentionally, knowingly, and recklessly. Intentionally done with the direct purpose of causing harm that results harm to a child. Knowingly, being aware that harm is practically certain to result. Recklessly, conscious disregard of substantial or unjustifiable risk causing harm or to endanger the child. Now let's explore who is considered a perpetrator. Perpetrator is an individual who has committed child abuse as defined by Pennsylvania Child Protective Services. Unfortunately, most child abuse occurs within a child's own family by person known to the child. Let me repeat that. Unfortunately, most child abuse occurs within a child's own family by person known to the child. So the term perpetrator includes any of the following: parent of a child, a spouse or former spouse of the child's parent, a paramour, lover, or former paramour of the child's parent. According to Act 15 of 2015, a person 14 years of age or older who is responsible for the child's welfare or having direct contact with children as an employee of a child care services or at a school or through a program, activities, or services. An individual 14 years of age or older who resides in the same home as a child could be also a perpetrator. A person with whom someone is having a romantic or sexual relationship, or especially a secret or improper relationship. An individual 18 years of age or older who does not reside in the same home as the child but is related within the third degree of consanguinity or affinity by birth or adoption to the child. Children may also be abused in institutional or community setting by those known to them. More rarely, this is important, a stranger as a perpetrator. Not uncommon, but rare. An individual 18 years of age or older who engages a child in severe form of trafficking in person or sex trafficking, as those terms are defined under Section 103 of the Trafficking Victim Protection Act of 2000. Nothing under the Pennsylvania CPSL, Child Protective Services Law, requires a person who has reasonable cause to suspect a child is a victim of child abuse to identify the person responsible for the child's abuse in order to make a report of suspected child abuse. So you don't need to know who is the perpetrator, you just need to report. Only the following may be considered a perpetrator for failing to act as provided in this section. A perpetrator for the child abuse can be a child's parent, a spouse or former spouse of a child's parent, the person responsible for the welfare of a child, such as babysitter or daycare staff person, an individual residing in the same home as the child who is at least 14 years of age, or a paramour or lover of the child's parent, regardless of whether or not they reside in the home. Remember, as a mandated reporter, you do not have to determine whether or not the person meets the definition of perpetrator in order to make this report. It is also important to repeat that the law considers both an act of harm to a child and failure to act to prevent harm to a child when defining an act of a child abuse. The other GPS cases include a child that is without a parent, guardian, or legal custodian, or is habitually and without justification subject to trauma, both physical and emotionally, at a school while subjective to compulsory school attendance, or has committed a specific act of habitual disobedience of the reasonable and lawful commands of their parents, guardian, or other custodian, and who is ungovernable and found to be in need of care, treatment, and supervision. The other case is a child who is under 10 years of age and has committed a delinquent act, or one that has been formerly adjunctuated dependent and is under the jurisdiction of the court, subject to its condition or placement, and also commits an act which is defined as ungovernable. The other situation is a child that has been referred and who commits an act which is defined as ungovernable. Remember, act and failure to act both are equal to child abuse. What's the basis to report a child abuse and neglect? As a mandated reporter, you are legally obligated to report suspected child abuse or neglect if you come in contact with a child during the course of your employment, occupation, or profession, or if there is a regular scheduled program activities or services, or if you as a mandated reporter are directly responsible to care for a child under your supervision, training, guidance, or you're affiliated with an agency, school organization, religious organization, and other entities. The other situation is that if a person 14 years or older reports to you that a child is victim of abuse, then you must immediately report that case. You are mandated to report also if a person makes a specific disclosure to you as a mandated reporter that an identifiable child is a victim of a child abuse. The same situation applies if an individual 14 years of age or older makes a specific disclosure to the mandated reporter that the individual has committed child abuse. When reporting suspected child abuse according to Act 18, which is related to crime and offensive, it clearly explains that nothing under Pennsylvania CPSL or Child Protective Services law requires that a child to come before the mandated reporter in order to make a report of suspected child abuse, nor that the mandated reporter must identify the person responsible for the child abuse in order to make a report of suspected child abuse. So none of that is required. Basically is to have a reasonable cause to suspect and to report. So what does the law mean by reasonable cause to suspect? First is familiarity with the individual, family situations and relevant history or similar prior incidents, etc. It is also important to recognize how your feeling and personal bias may influence your conclusion and action. Your reasons to determine to report may be based on your training, experience, and all known circumstances, including who and what and when and how and observation. Indicators of abuse or red flags, behaviors or demeanors of a child or children. Of course, you may consider behavior and demeanor of the adult as well. Some indicators may be more apparent than other depending on the type of abuse and or depending on the child's health, development and well-being, as well as may be physically visible on the child's body, while other indicators may be present in the child's behavior. Persons required to report suspected child abuse, in whatever position you are as a mandated reporter, a member of the staff of a medical, dental practice or institution, or a member of a public or private institution, a school facility or agency, you must report immediately. Then notify the person in charge of the facility too. Upon notification of the abuse, the person in charge or the designated agency, if any, shall facilitate the cooperation of those facilities or agencies with the investigations of the report. Any intimidation, retaliation, or obstruction in the investigation of the report is subject to the provision of Pennsylvania CPSL law related to intimidation, retaliation, or obstruction in child abuse cases. The Pennsylvania CPSL or Child Protective Services law does not require more than one report from any such institution, school, facility, or agencies. Simply said, if you have reasonable cause to suspect, make a report. As mandated reporter, making an oral report of suspected child abuse to the DHS via the statewide toll-free telephone number shall also make a written report using a form CY-47, which may be submitted electronically within 48 hours to DHS or county agencies assigned to the case in a manner and format prescribed by DHS. The failure of the mandated reporter to file the written report of this CY-47 shall not relieve the county agencies from any duty under the Pennsylvania Child Protective Services law, and the county agency shall proceed as though the mandated reporter comply. A mandated reporter shall immediately make an oral report of suspected child abuse to DHS via the statewide toll-free telephone number 1-800-932-0313 or a written reports using that electronic portal of campus.state.pa.us. This is important to remember that individuals who are supervised or managed by a mandated reporter and have direct contact with children at work are also mandated reporter. If you teach at a school and you see a child who is a victim of a child abuse, you are mandated to first report it immediately to Childline, then inform your director, chairman, or in professional school or administrative person. Childline will finally determine the next step. The statewide toll-free number that I just mentioned is available for any individual, whether mandated by law or not, to use to report cases of suspected child abuse or children allegedly in need of general protective services. When we talk about electronic reporting, a confirmation by DHS of the receipt of the report of suspected child abuse submitted electronically shall relieve the person making any additional oral or written report of suspected child abuse. How about confidentiality of the report? Any individual obtained reports, written or photograph or x-ray taken concerning alleged instances of a child abuse in the possession of the DHS or county agency shall be confidential. Protecting identity. Law enforcement officials shall treat all reporting sources as confidential information. Reports are protected by a strict confidentiality provision. Amendment to the Child Protective Services Law prohibits the department, county, institution, school, facility, or agency, or designated agent of the person in charge from identifying the person who made a report of suspected abuse or who cooperated in a subsequent investigation. To report electronically, this is preferred method of reporting. When reporting electronically, you do not need to complete the paper format of CY 47 as your electronic report satisfied this requirement. Your report will be forwarded to the appropriate county children and youth agency. In order to make a referral, you must have an account. If you have already registered and have a Keystone ID, you may log in. New users should select create a new account. So again, mandatory reporters are encouraged to report suspected abuse online, to report over the phone or call Childline at 1-800-932-0313, which is open 24/7. Provide as much information as possible. If a child has made a disclosure, use the same language the child used. Provide as much information as possible. Assist the county children and youth agency to make a preliminary assessment of the child's safety. So what must be reported? First of all, remember that a mandated reporter isn't required to know all of this information in order to make a report. The information should be reported only if known. A written report of suspected child abuse, which may be submitted electronically, shall include the following information if known: the name and address of the child's parent, and any other person responsible for the child's welfare, where the suspected abuse occurred, the age and sex of each subject of the report, the nature and extent of the suspected child abuse, including any evidence of prior abuse to the child or any sibling of the name and relationship of each individual responsible for causing the suspected abuse or any incident or evidence of prior abuse by each individual. If you already know about family composition, the other issues are family composition, the source of the report, the name, telephone number, and email address of the person making the report, any other information that DHS requires by regulation, any other information required by federal law or regulation, Action taken by the person making the report include taking pictures, x-rays, medical tests of the child subject to report. Other things that should be included are relating to taking child into protective custody, relating to admission to private and or public hospital, relating to mandatory reporting and post-mortem investigation of a death. Application of Mental Health Procedure Act. Notwithstanding any other provision of law, a mandated reporter who makes a report of suspected child abuse and who makes a report of a crime against a child to law enforcement officials shall not be in violation of the Act of July 9 of 1976, known as Mental Health Procedure Act, by releasing information necessary to complete the report. So what happens after a report is made? Childline receives the report and determines who is to respond to the report depending upon the information reported, such as identity, if known, of the person who allegedly acted to abuse or harm a child. Childline will immediately transmit oral and electronic report they receive to the appropriate county agency and or law enforcement official. If a person identified falls under the definition of perpetrator, Childline will refer the report to the appropriate county agency for an investigation. If the person identified is not perpetrator and the behavior reported includes a violation of a crime, Childline will refer the report to law enforcement. If a person identified falls under the definition of perpetrator and the behavior reported includes a criminal violation, Childline will refer the report to the appropriate county agency and law enforcement official. The important question a mandated reporter may want to know if there is immunity from liability. A person, hospital, institution, school, facility, agency, or agency employee acting in good faith shall have immunity from civil and criminal liability that might otherwise result from any of the following: mandated reporter making a report of suspected child abuse or making referral for general protective services regardless of whether the report is required to be made under the Pennsylvania Child Protective Services Law. Cooperating, consulting with an investigator under the Pennsylvania CPSL or Child Protective Services Law, including providing information to a child fatality or near fatality review team. Testifying in a proceeding arising out of an instance of suspected child abuse or general protective services. Engaging in any action authorized, photograph, medical test, x-ray of a child subject to the report, taking the child into protective custody, administration to private and public school, mandatory reporting, and post-mortem investigation of a death. How about immunity for the department and county agency officials or employees? An official or employee of the DHS or county agency who referred report of suspected child abuse for general protective services to the law enforcement authorities or provides services as authorized by the Pennsylvania Child Protective Services Law shall have immunity from civil and criminal liability that might otherwise result from the action. Presumption of good faith of a mandated reporter. For the purpose of any civil or criminal proceeding, the good faith of a person required to report suspected child abuse and any person required to make a referral to the law enforcement official under the Pennsylvania CPSL shall be presumed. After a referral or report is made, when a county agency or law enforcement receives a referral or report, the county agency or law enforcement official is to notify DHS after ensuring the immediate safety of the child and any other child or children in the child's home. When Childline receives a referral report, Childline will immediately evaluate and transmit the information to the appropriate agency for assessment and investigation. If the suspected child abuse is alleged to have been committed by a perpetrator, Childline will transmit the information to the county agency where the suspected child abuse is alleged to have occurred for investigation of allegations. How about referral to county agencies or GPS? If the referral or the report does not suspect the child is in need of protective service, but suggests that the child is in need of other services, Childline will transmit the information to the appropriate county agency for assessment of the needs of the child. Next is referral to county agency and law enforcement official. If the suspected child abuse is alleged to have been committed by a perpetrator and the behavior constituting the suspected child abuse may include a violation of the criminal offensive, the Childline will transmit the information to the appropriate law enforcement official in the county where the alleged to have occurred for a joint investigation of allegation or allegations. However, if the person suspected of committing child abuse is not a perpetrator, but the behavior constitutes the suspected child abuse may include a violation of a criminal offense, Childline will transmit the information to the appropriate law enforcement official in the county where the suspected child abuse is alleged to have occurred in investigation. Once again, answering this important question should be simple. What if I'm not sure if it is child abuse? As a mandated reporter, you only need to have reasonable cause to suspect that the child is a victim of abuse. You do not have to know for certain whether abuse occurred. A specially trained child welfare professional will determine if the child is victim of abuse and what action to take. So let's next look at what are the categories of child abuse. There are predominantly 9 categories that contribute to defining child abuse. I will present you with an overview of these factors as defined by the Child Protective Service laws and then break down those factors, providing you with examples and details. The law considers 2 parameters, pain and impairment, when describing bodily injury. When an individual intentionally, knowingly or recklessly harming a child by doing any of the following: causing bodily injury to a child through any recent act or failure to act, fabricating, feigning or intentionally exaggerating or inducing medical symptoms or disease which result in potentially harmful medical evaluation or treatment to the child through any recent act, causing or substantially contributing to serious mental injury to a child through any act or failure to act or series of such act or failure to act, causing sexual abuse or exploitation of a child through any act or failure to act, creating a likelihood of sexual abuse or exploitation of a child through any recent act or failure to act. Sexual abuse or exploitation does not have to occur. The individual's behavior creates a very good chance of sexual abuse or exploitation occurring to a child. Serious physical neglect includes endangering a child's life or health or threatening a child's well-being, creating a reasonable likelihood of bodily injury to a child through any recent act or failure to act, causing bodily injury or impairing a child's health, development or function due to repeated or prolonged failure to supervise a child, considering the child's age and development, failure to provide a child with adequate essential food, clothing, shelter or medical care, causing serious physical neglect of a child, engaging in any of the following recent acts: kicking, biting, throwing, burning, stabbing, or cutting a child that endangers the child, forcefully shaking a child under 1 year of age, unreasonably restraining or confining a child based on consideration of the method, location, and duration of the restraint or confinement, forcefully slapping or otherwise striking a child under 1 year of age, interfering with the breathing of a child, causing a child to be present at a methamphetamine lab while being investigated by law enforcement. According to Pennsylvania Child Protective Services law, leaving a child unsupervised with an individual other than the child's parent, who the parents or the actor knows or reasonably should have known that that person is required to register as a Tier 2 or Tier 3 sexual offender, where the victim of the sexual offense was under 18 years of age when the crime was committed, or that person has been determined to be sexually violent predator or any of its predecessor, or has been determined to be sexually violent delinquent child, has been determined to be sexually violent predator, or has to register for life, and worse than that, causing the death of a child through any act or failure to act, and also engaging a child in severe form of trafficking in person or sex trafficking, as those terms are defined under Section 103 of the Trafficking Victim Protection Act of 2000. In Pennsylvania, the law classifies child abuse and neglect in 4 different ways or 4 different categories. Physical abuse is the first one. Second one is sexual abuse and exploitation. Third one is mental abuse, and fourth one is neglect. Let me explore these 4 categories. First category is physical abuse or bodily injury, which causes impairment of physical condition or substantial pain. Impairment of physical condition refers to the injury where the child's ability to function is reduced temporarily or even permanently in some cases. Substantial pain refers to a child that experiences what a reasonable person believes to be substantial pain. As an oral maxillofacial surgeon treating trauma cases, I have seen many forms of physical abuse, such as a slap injury to the face of a school-age child, showing as clear marking on the child's face, dental injury causing teeth loss and evasive injury of the teeth. I've also seen and treated hundreds of cases of facial fractures as a result of violent physical trauma and abuse. We may see severe bodily injury that lead to impairment of physical condition or, like I said, substantial pain. Medical practitioner may see or treat children for clear injury caused by physical abuse. As illustrated here, a scaled burn was inflicted in the child's body. You could see clear demarcation of the burn on this child's lower extremities. So what are the behavior indicator of physical abuse? Now that we learned about physical indicator of child abuse, let's explore the behavior indicator of physical abuse. The following words and phrases, when used in the Pennsylvania Child Protective Service law, shall have the meaning given to them in the section unless content clearly indicate otherwise. Bodily injury, impairment of physical condition or substantial pain. Following are some of the behavioral indicators which may suggest possible physical abuse. The child is usually wary of physical contact with adult. The child seems to be unduly frightened of a parent, guardian, or caregiver or another adult, and be fearful of going home. The child does not show emotion when hurt. The child may have extreme apprehension or vigilance, or may have pronounced aggregation or passivity, and also child avoid being touched. If there are any injury, the child may be unable to recall how injury occurred or given inconsistency story. The other issues in behavior as behavioral indicator of physical abuse is pronounced aggression or passivity, flinches easily or avoid being touched. Play includes abusive talk or behavior. The child have unexplained injuries and unbelievable or inconsistent explanation of the injury, or the injury are inconsistent with the child's age and developmental level. Also, he or she is unable to recall how injury occurred, or account of injury is inconsistent with the nature of the injury, as I said before. Multiple bruises in various stages of healing is seen on the child's body in this slide. Bruises located on face, ear, neck, buttock, back, chest, thigh, back of the leg, and genitalia. Bruises that resemble objects such as a hand, fist, belt buckle, or rope, or the child has burn mark. Most commonly occurring injuries in the kitchen or bathroom. Greatest number of pediatric burn patients are infant and toddler younger than 3 years of age, burned by scalding in liquid. Bath gulps often associated with lack of supervision or child abuse. Burn pattern, when we compare accidental burn versus abusive burn. When we speak about burn, one must keep the differentiation of the burn pattern and distinguish accidental burn from abusive burn. For those who have children, it is not uncommon that a child are curious about everything that is within their reach. A splash mark pattern is common demarcation of accidental burn, but burn with clear demarcation of the burn, as you see on this slide, called the dip burn, is most probably inflicted burn. Illustration shows the different type of burn for young children, ranging from tip, walker, and dip burn pattern seen in accidental versus abusive burn is illustrated here. Note the extent of the pattern and the pattern. Several burn characteristics can help differentiate between inflicted and accidental burn. Obviously, these burns are inflicted in this child, as it appears on both hands with third-degree burns. Physicians are well trained to ask parents as well as the child to rule out one way or the other if the child is older, of course. These are examples of marks of physical abuse. Unfortunately, physical abusers and perpetrators use a variety of tools to inflict burns to children. Here are a few example marks from instruments such as belt buckles, belt, loop cord, even fly swatters and coat hangers, wooden boards, metal spatula, and hand knuckles. In many cases, we can find bite marks on child's face or hand and arm, and many more tools have been used by abusers and seen in the ER by the physicians. I've seen cases of injury caused by knife, car cigarette, lighters, as well as cigarette burns mark, to just name a few. Grabbing a child's ear and causing trauma is actually commonly observed by healthcare professionals. These inflicted ear bruises occur with pinching, pulling, twisting, cuffing, and punching. This child was brought to the ER to evaluate swelling, bruises, and pain. As the physician began examining the child cries when his right arm is touched. He has also bruises on his buttock. Swelling near the wrist and arm was noted. An X-ray is taken from the right arm, which shows a clear fracture. This type of fracture, called a spiral fracture of the femur or humerus in non-ambulatory children, is seen in the emergency room often. And the most common mechanism of this fracture is forceful jerking or twisting of the extremities while being held near the knees or elbow. One thing that I have learned in my many years of treating trauma cases is that a patient with one injury may have further injuries or more injuries that are not visible. In this case, additional shoulder injury was also discovered. If you see signs of injury to the face or mouth, if possible, request a comprehensive medical evaluation prior to your procedure. Dental professionals should only limit their examination based on the scope of their practice, not beyond. Although physicians receive minimal training in oral health and dental injury and diseases, they are able to detect aspects of abuse or neglect associated with other areas of the body. Therefore, physicians and dentists are encouraged to collaborate to increase the prevention and detection and treatment of these conditions. Now, let's stop here and check your knowledge with a hypothetical scenario. You are a registered nurse in a triage at the emergency department and receive a call that a parent is bringing his 6-year-old son with a possible broken arm. Upon arrival, the child's father tells you that their family dog accidentally knocked his son over and that he fears he may have broken his arm. Upon assessment, you diagnose an open fracture of the patient's right arm and notice faded bruises to the child's torso, face, and arm. The ulnar fracture or the right arm fracture appears to have been snapped. The injury does not seem consistent with the story the patient's father tells you. What are the warning signs for this scenario? What should you do? So, potential sign of physical abuse due to multiple sites of injury and inconsistent history given by the father are the major warning sign. And then the next question is, what should you do? You should document what you have observed and make a report, since the father's report is not consistent with your findings. So let's look at the second category of child abuse, which is sexual abuse and exploitation. The only way to stop sexual abuse and exploitation is to be vigilant and take action in reporting these cases. Unfortunately, more than 70% of child sex abuse cases involve a relative, friend, or someone else close to the child. So according to the Act 115 of 2016 regarding severe form of trafficking in person, sex trafficking in which a commercial sex act is induced by force, fraud, or coercion, or in which the person induced to perform such act has not attained 18 years of age, or definition of sex trafficking is defined as the recruitment, harboring, transportation, provision, or obtaining of a person for the purpose of commercial sex act. So what's the definition of commercial sex act? Is defined as any sex act on account of which anything of value is given or received by the person. The recruitment, harboring, transportation, provision, or obtaining of a person for labor or services through the use of force, fraud, coercion, for the purpose of subjection to involuntary servitude, peonage, debt bondage, and slavery. So let's see, what do they mean. Peonage which is paying off debt through work. Debt bondage is called debt. Slavery is bonded labor for services for a debt or other obligation. And slavery is defined as a condition compared to that of a slave in respect of exhausting labor or restricted freedom. How about labor trafficking? Is defined as labor obtained by use of threat of serious harm, by threatening a person to harm them, use of physical restraint, or abuse of legal process. A few examples include being forced to work for little or no pay, which frequently may happen in factories or farms. Domestic servitude is explained as providing services within a household for 10 to 16 hours per day, such as but not limited to childcare, cooking, cleaning, yard work, gardening, etc. When we talk about sexual abuse and exploitation, more than 70% of child sex abuse cases involve a relative, friend, or someone else close to the child. So the employment, use, persuasion, inducement, enticement, or coercion of a child to engage in or assist another individual to engage in sexually explicit conduct, which include but not limited to the following: looking at sexual or other intimate part of a child or other individual for the purpose of arousing or gratifying sexual desire in any individual, participating in sexually explicit conversation either in person, by telephone, by computer, or by computer-aided devices for the purpose of sexual stimulation or gratification of an individual, actual or simulated sexual activity or nudity for the purpose of sexual stimulation or gratification of any individual, actual or simulated sexual activity for purpose of producing visual depiction, including photography, videography, computer depicting, or filming. This does not include consensual activities between a child who is 10 years or whose age is within 4 years of the child's age. When the law discusses sexual abuse or exploitation, it refers to any of the following ones committed against a child as defined within the Pennsylvania criminal law: rape, statutory sexual assault, involuntary, deviant sexual intercourse, sexual assault, institutional sexual assault, aggregated indecent assault, and rape. Rape in common law jurisdiction, statutory rape is non-forcible sexual activities in which one of the individual is below the age of consent, the age which is required legally consent to the behavior. A statutory sexual assault and sexual assault contact without consent is one way of defining it. Sexual assault is an act in which a person intentionally sexually touches another person without the person's consent, or coerces or physically forces a person to engage in a sexual act against their will. A statutory sexual assault is defined as a person engaging in sexual intercourse with a victim to whom the person is not married, who is under the age of 16 years, and that person is either 4 years older but less than 8 years older than the victim, or 8 years older but less than 11 years older than the victim. Involuntary deviant sexual intercourse, institutional sexual assault, a person who is an employee or agent of the Department of Correction or a county correctional authority, youth development center, youth forestry camp, state or county juvenile detention facility, and other licensed residential facilities serving children or youth, or mental health or mental retardation facility or institution, commits a felony of the third degree when the person engages in sexual intercourse, deviant sexual intercourse, or indecent contact with an inmate, detainee, patient, or resident who is under 18 years of age. The institutional sexual assault also applies to a person who is a volunteer or an employee of a school, or any other person who has direct contact with a student at a school. Aggregated indecent assault. This statute defines aggregated indecent assault as engaging in sexual intercourse when the victim is not conscious or unaware of the penetration, or when a person has given the victim drugs or other substances that would prevent them from resisting. So, what is included in sexual abuse or exploitation? Indecent assault, indecent exposure, incest, prostitution, sexual abuse, unlawful contact with a minor, and sexual exploitation. Who are at risk of human trafficking is the next area that I like to cover. The people that are at risk of human trafficking are youth in foster care system, youth who identify as LGBTQ, lesbian, gay, bisexual, and transgender, youth who are homeless or runaway, youth with disability, youth with mental health or substance abuse, and youth with history of sexual abuse, youth with history of being involved in the welfare system, youth who identify as native or aboriginal, youth with family dysfunction. So what are the behavioral signs of sexual abuse? Self-harm is one of them. There are multiple warning signs of possible sexual abuse in a child behavior that we must pay attention. Many of these indicators may occur in children who have not been abused and may not be seen in children who have been abused. The behavior indicator of sexual abuse includes a young child that is sexually promiscuous, developmentally age-inappropriate sexual play, mimicking adult-like sexual behavior with toys or a stuffed animal, sexual theme in the child's artwork and stories ask other children to behave sexually or play sexual game, cruelty to others and cruelty to animal, fire setting, anxious, withdrawn, sleep disorder, disturbances, and bedwetting too. Other signs may include pain or irritation in genital and anal area, difficulty walking or sitting, difficulty urinating, pregnancy, positive testing for sexually transmitted disorder or diseases such as HIV, excessive or injurious or harmful masturbation, suddenly refuses to go to school, psychosomatic indicator, which are withdrawn and depressed and anxious, phobias and obsession, refusing to change for physical exercises and or participation in physical activities, running away, drugs, solvent or alcohol abuse, avoid or is afraid of being left alone with people or a specific person. Victim identification and warning sign includes but not limited to a youth that has been verified to be under 18 and is in any way involved in the commercial sex industry or has a recent or prior arrest for prostitution or related charges, has an explicitly sexual online profile, excessive frequenting of internet chat room and classified site, depict element of sexual exploitation in drawing, poetry, or other models of creative expression, frequent or multiple sexual transmitted diseases or pregnancies, lying about, not being aware of their true age, having no knowledge of personal data such as but not limited to age, name, and or date of birth, having no identification, wearing sexually provocative clothing, wearing new clothes of any style, getting hair and or nail done with no financial means, secrecy about whereabouts. Other warning signs may include having late nights or unusual hours, having a tattoo that he or she is reluctant to explain, being in a controlling or dominating relationship, not having control of own finances, exhibit hypervigilance or paranoia or paranoid behavior, express interest in or in relationship with adult or much older men or women. Now, with all the information given, let's check this next scenario. You're working as a school nurse at an elementary school. You receive a call from a teacher who says he is sending a 5-year-old student named Gina to your office. He says Gina is unusually quiet today, complaining of pain in her stomach and saying she needs to vomit. You meet her in the hallway and escort her to your office. Just then Gina starts vomiting into a trash can you handed her, and you notice that what appears to be dried blood on the back of her pants near her buttocks. You ask Gina if she has started her menstrual period, and she says she has never had one before. Gina looks embarrassed and tells you that her stomach and bottom hurts and she wants her mom to pick her up. What are the warning signs for this scenario? What would you do? The warning sign, of course, blood, stomach and buttocks pain, vomiting, embarrassment. And what would you do? It seems that this child has been a victim of sexual abuse but reluctant to talk about it. You should make a report to Childline if you have a reasonable cause. Okay, now let's talk about the next category of child abuse, which is mental abuse. Like physical abuse, emotional abuse, and neglect can also leave deep, lasting scar. They may involve serious mental injury. So what is serious mental injury? Is a psychological condition as diagnosed by a physician or licensed psychologist, including the refusal of appropriate treatment that renders a child chronically and severely anxious, agitated, and depressed, socially withdrawn, psychotic, or in reasonable fear that the child's life and safety are threatened. Seriously interferes with a child's ability to accomplish age-appropriate development and social tasks. Serious mental abuse may interfere with the child's ability to accomplish age-appropriate development and social tasks. Mental abuse may also include interactions that are beyond the child's developmental capability, as well as overprotection and limitation of exploration and learning, or preventing the child participating in normal social interaction. It may feature age or developmentally inappropriate expectation being imposed on the child. It may include not giving the child's opportunity to express their view, deliberately silencing them, or making fun of what they say or how they communicate. Serious mental abuse may include serious bullying, including cyberbullying, causing children frequently to feel frightened or in danger, leading to exploitation or corruption of the child. So the physical indicator of mental abuse includes depression or absence of affect, frequent psychosomatic complaints such as nausea, headache, vomiting, stomachache, alcohol or drug abuse, speech disorder. Behavioral indicator of mental abuse may include expressing feeling of inadequacy and constantly worrying about doing something wrong, or being depressed and having low self-esteem. Antisocial behavior, including cruelty to other children or cruelty to animals. Neurotic traits such as extreme fearfulness, a speech disorder or problem, or delays in learning and emotional development, doing poorly in a school, expressing feeling of inadequacy, fearful of trying new things, excessive dependence on adult, habit disorders such as sucking or rocking in the chair, eating disorder, bedwetting, and self-harm. The next category is serious physical neglect. More serious neglect can endanger a child's life or health, threaten a child's well-being, causes bodily injury, or impair a child's health, development, and function. In Pennsylvania, this serious physical neglect is considered a form of child abuse. Severe dental caries is often ignored by parents. We hear this comment from few parents: they were just baby teeth, and my child was going to lose them anyway, so it doesn't matter if they have lots of cavity, and they would be lost at a very early age. Serious physical neglect may include any of the following when committed by a perpetrator that endangers a child's life or health, threatening a child's well-being, causes bodily injury, or impairs child's health, development, or function. A repeated, prolonged, or intentional failure to supervise a child in a manner that is appropriate considering a child's developmental age and ability. The failure to provide a child with adequate essential of life, including food, shelter, and medical care. What is considered serious physical neglect? Any of the following when committed by a perpetrator that endangers a child's life or health, threatens a child's well-being, causes bodily injury, or impairs a child's health, development, and function. The child's weight is significantly lower than normal for their age or gender, developmental delay, persistent untreated conditions such as head lice, diaper rash, and so on, exposure to hazardous material or hazards, for example, illegal drugs, rodent, insect infestation, and mold, clothing that is dirty, inappropriate for the weather, they are either too small or too large. And then the indicator for serious physical neglect includes not registered in a school, inadequate or inappropriate supervision, poor impulse control, lack of frequently fatigue, parentified behavior, lack of adequate medical or dental care, and often hungry. Now let's look at another scenario. Sophia, a 3-year-old child seen in pediatric dental office, has had a severe cough during the last 2 visits in 15 days. Her cough is so bad that her whole body seizes up when she coughs. She sneezes and appears exhausted. You are very concerned about her general health and have expressed your concern to her mom. Mom just kept saying, "It is getting better. The pediatrician will just tell me it is cold and there's nothing they can do. It is waste of time." Sophia may be experiencing medical neglect. Sophia's mother does not seem to be providing necessary medical care despite the financial means to do so. What should you do? The correct answer is document what you have observed and make a report to Child Line. When we talk about the neglect, the American Academy of Pediatric Dentistry says the willful failure of a parent or guardian to seek or follow through with treatment necessary to ensure a level of oral health essential for adequate function and freedom from pain and infection is crucial. If they don't do that, then that would be neglect. As dental professionals, we observe pediatric cases with variety of injury, including loosened, fractured, or avulsed teeth, severe trauma to the lower face may loosen teeth completely displace them from their alveolar socket and or cause dental fracture. It is not uncommon for root fracture to occur, but this finding may be missed unless the radiograph are examined carefully. These injuries, as well as most other traumatic injury, may be accidental rather than abusive. In many cases, they are due to sport injury or fall. Therefore, one must always determine whether the injury is compatible with the explanation given. If the dental injury resulted from a fall, for example, one would expect to also possibly find bruises or abraded knees, hands, or elbow. When these additional injuries are not present, further inquiry is required. On the other hand, a sports-related injury to the face or to teeth do not need to have other signs and usually is clear-cut to dental professional. One of the common areas of dental professional and particularly oral surgeons and pediatric dentists is to evaluate patients with severe orofacial injury either as a result of an accident or abuse and neglect. These injuries may include laceration in the labial and lingual frenum, buccal mucosa, lip, alveolar, gingival margin, and tongue. Obviously, we take x-rays to evaluate alveolar as well as mandibular and maxillary fractures. Another injury shown here is teeth intrusion from accidental injury. When we talk about tooth avulsion, although this is non-specific for abuse, as fall or sport injury could be the cause of it, may result from direct force apical to the crown of the tooth, a force required to move the tooth out of its position in the jaw, almost exclusively limited to anterior teeth because of their single-rooted structure, sufficient blow to the alveolar ridge of the mouth can result in this type of trauma. I've seen many cases of tongue injuries, mostly caused by accidental trauma. But when we see bite mark, like the pictures shown here, with indentation of the teeth in the wrong direction, as the child's teeth, it is indication of abusive injury. Other soft tissue injuries, trauma to the mouth, may also cause ulceration of the palate or uvula. Additional laceration are sometimes found in the floor of the mouth, which may be caused by forced bottle feeding. So, bite mark curvature direction useful in determining if it is self-injury, accidental, or inflicted. When I see a patient with any type of injury, I want to determine the history of the trauma just by asking few questions. When and where did the injury occur? Who was caring for the child at time of injury? Was anyone else there? Was there any witnesses? What event preceded or led to the injury? What was the child's reaction? Was he in pain, crying, or bleeding, or having any other symptom or reaction? What did the caregiver do? Did they seek immediate care or delayed seeing a medical or dental professional? There are so many obvious red flags that you must pay attention to. What distinguishes the infant who has been abused to the infant with some other causes for their symptom? There are some indicators of abuse which should prompt suspicion on the cause of the infant's clinical status. When you look at the injury and after you examine, does the way that the caregiver explains to you make sense as far as the degree of the mechanism of the injury? Is that injury compatible with the child's developmental ability or not? The caregiver may change their story or make up new stories as you question them. I've had patients with severe facial trauma and their parents claim that they have no idea what happened. So listen carefully to their history as explained by them. Is it absent, changing, or evolving? Delay in seeking medical care is another issue that once again I have seen for a child that was brought to the emergency room many days after the accident, when bruises are fading or the site of injury is almost healing. Lastly, ask the parent or the caregiver what was the triggering event. Other area of concern or red flags include caregiver unrealistic expectation, social or physical isolation, pattern of increasing severity or escalation of the event, family crisis or stress. When we speak of neglect, there are many signs of neglect that dental practitioner can easily recognize, document, and report. I remember reading a story about a mother in Florida who was arrested for child neglect after apparently failing to address her daughter's dental need, to the point where the child's teeth were severely decayed and requiring extraction. As dental practitioners, particularly the ones caring for the children, pediatric dentists, to be vigilant when noticing these type of neglect, especially for children younger than 18. Keeping these points in mind, let's hear about this next learning point scenario. You see a family of 4 in your dental office. You notice that the 5-year-old girl has multiple decayed teeth in both arches, and her older brother, who is 9, also has an even worse condition requiring multiple root canals and extraction of permanent teeth. The other 2 children who have broken front teeth and extremely poor oral hygiene. The mother leaves the office for a smoke and seem to be frustrated from the delay in their care today. What are the warning signs for this scenario? What would you do? The warning signs for this scenario are failure to provide adequate dental care, prolonged and repeated lack of supervision and dental care at home, failing to protect children from physical and emotional harm or danger, and finally persistent untreated condition leading to major dental issue. What would you do is the next question. Remember, you should not delay in providing dental care for the emergency services, but if have reasonable cause to suspect neglect, you should report to Childline. An important issue of concern when we speak of physical neglect is during pregnancy, if the mother is using recreational or other harmful substances. Neglect can be as detrimental as physical or emotional abuse in child's life, as seen from the CT scan of a 3-year-old. Normal versus extreme neglect. Note lack of brain and skeletal development in the child that was neglected. These are behavioral indicator of neglect. When the child is not registered for a school or comes to school frequently tired, fatigued, or exhausted, gets upset easily and has poor impulse control, is mistrusting, the child takes the role of a parent taking care of younger children in the family, known as parentified behavior, and failure to thrive and lack of interest to be successful. Factor affecting a child's response to abuse. Here are a few examples. The child's age. Very young children may not remember the abuse. Length of the abuse. The longer the duration of abuse, the more harm or longer lasting effect. Frequency of the abuse. Relationship with abuser. Parental abuse most frequently occur in the form of over-discipline, is generally a response to prior conflict with the child and may be inadvertently supported by parental permission for corporate punishment. The effect of this type of abuse may last a lifetime. Next one is the type of abuse. Remember, a child's abuse and severity of abuse could have long-lasting effect on the child. And finally, the availability of support to the child is important. There are many behaviors that indicate abuse might be involved. There are some common behavioral signs that crosses categories of physical, sexual, mental, and neglect. We must be aware. I've created this chart that shows those commonalities. These conditions could have any of the following serious behavioral problem. First is withdrawn from others and wanting to be left alone. Then have low self-esteem, or the child could be having problem at the school with having very poor performance, or may not even show up at the school, fearful of physical contact at the school and beyond, more tendency to use or abuse so-called recreational substances, always looking to get more attention. They may have depression or have severe anxiety. They may demonstrate behaviors which are inappropriate for their age. How can you determine a reasonable cause to suspect? This is an important concept that you have to keep in mind. Is there a reasonable cause? Let's assume a patient comes with trauma history. Well, we look at the circumstances based on the history of the injury and our observations. We also evaluate the frequency or familiarity to this situation and the case. If this child has had the same trauma just recently, but the parent had a different story, that should be of concern. Then we put all those things together and consider the situation and how we feel about this case. Based on scientific knowledge, we have reasonable to be suspicious. The law stresses primarily on this reasonable suspicion to report. We have to look at the circumstances that the injury happened. Who caused it? What happened? When, where, and how? Where did the injury occur? When did it happen? What type of injury? What caused the injury? Who was caring for the child? Was anyone else there to witness that injury? What event preceded the injury? What was the child's reaction, and what did the caregiver do? Now, from your observation of the injury, think of the red flag. Is this injury inconsistent with the degree and mechanism of injury? Is it incompatible with the child's developmental ability? Is the story absent, changing, or evolving? Was there any delay in seeking medical care? Any triggering event? How about familiarity? As I said before, the familiarity to the individual and the family is important. Has this type of injury occurred previously? Is the caregiver's expectation unrealistic? Is there any social or physical isolation? Is the pattern of injury increasing in severity, or even the event have escalated significantly? Do you have familiarity to the families and know if they have a crisis or significant stress? Finally, do you have a gut feeling that the child is being neglected or abused, considering all of these factors? You need to have a reasonable cause that abuse or neglect occurred to report. And importantly, the sooner the abuse is identified, the faster welfare professional can address the issues and rectify the problem. For our listeners, this is very important to be proactive in reporting any categories of abuse or neglect you see. Our goal is to save a life, and that's the purpose I'm creating this presentation. There are many potential long-term effects of abuse, as I mentioned before. First, there are physical health and could be affected, leading to chronic health condition, and there have been studies that shows brain development has been impaired in some event, causing severe cases of abuse. Psychological effects are more noticeable, to include poor emotional health, cognitive difficulties, as well as social difficulties. And then behavioral consequences are also long-lasting, and they include the child's delinquency, recklessness, and even criminal behavior. Substance abuse is another con. The abusive children will continue to demonstrate abusive behavior. There are few exclusions to child abuse when substantiating a report, reaffirming or confirming of culpability or liability. This refers to unintentional conduct that causes injury or harm to a child or create a risk of injury or harm to a child. This shall not be considered child abuse if there is no evidence that the person acted intentionally, knowingly, and recklessly when causing the injury or harm to a child or creating a risk of injury or harm to the child. To clarify child abuse exclusion, the term child abuse does not include any conduct for which an exclusion is provided in Section 6304 of Pennsylvania Child Protective Services laws relating to exclusion from child abuse. Please note that the state clarifies nothing in Pennsylvania Child Protective Services law requires a person who has reasonable cause to suspect a child is a victim of child abuse to consider the exclusion from child abuse before making a report of suspected child abuse. Exclusions from child abuse are considered and determined by DHS, the Department of Human Services, or the investigating agency after receipt of a referral and report. Then there are exclusions from child abuse as is related to the environmental factor. No child shall be deemed to be physically or mentally abused based on the injuries that resulted only from environmental factor, such as inadequate housing, furnishing, income, clothing, and medical care that are beyond the control of the parent or person responsible for the child's welfare with whom the child resides. This exclusion shall not apply to any children's services as the term is defined in the CPSL or Child Protective Services law, excluding an adoptive parent. How about exclusion from child abuse due to religious beliefs? In this regard, the law explains that if, upon investigation, the county agency determined that a child has not been provided needed medical or surgical care because of sincerely held religious belief of the child's parent or relative with a third degree of consanguinity, unity, meaning people who are related by blood from marrying or relationship by descent from a common ancestor, and with whom the child resides, which beliefs are consistent with those of a genuine religion, the child shall not be deemed to be physically or mentally abused. In such cases, the following shall apply. The county agency shall closely monitor the child and the child's family and shall seek court-ordered medical intervention when the lack of medical or surgical care threatens the child's life or long-term health. All correspondence with the subject of the report and the record of DHS and the county agency shall not reference child's abuse and shall acknowledge the religious basis for the child's condition. The family shall be referred for general protective services if appropriate. Importantly, this exclusion shall not apply if the failure to provide needed medical or surgical care caused the death of a child. This exclusion shall not also apply to any child care services as defined according to the Pennsylvania Child Protective Service laws, excluding an adoptive parent. How about use of reasonable force for supervision, control, and safety purpose as an exclusion from child abuse? Subject to subsection relating to the right of parents, the use of reasonable force on or against the child by the child's own parent or person responsible for the child's welfare shall not be considered child abuse if any of the following condition applies. The use of reasonable force constitutes incidental, minor, or reasonable physical contact with the child or other actions that are designed to maintain order and control, or the use of reasonable force is necessary to quell a disturbance or remove the child from the scene of a disturbance that threatens the physical injury or to person or damage to the property. The other areas are to prevent the child from self-inflicted physical harm, for self-defense or the defense of another individual, or to obtain possession of a weapon or the other dangerous object, controlled substances and paraphernalia that are on the child or within the control of the child. So nothing in the Pennsylvania Child Protective Service law shall be construed to restrict the generally recognized existing rights of parents to use reasonable force or on against their children for the purpose of supervision, control, and discipline of their children. Such reasonable forces shall not constitute child abuse. An individual participating in a practice or competition in an interscholastic sport, physical education, or recreational activity, or an extracurricular activity that involves physical contact with a child does not in itself constitute contact that is subject to the reporting requirement of the Pennsylvania Child Protective Service laws. Harm or injury to a child that is results from the act of another child shall not constitute child abuse unless the child who caused the harm or injury is a perpetrator. Notwithstanding or despite the above mentioned paragraph, the following shall apply. No child shall be deemed to be a perpetrator of a child abuse based solely on the physical or mental injuries caused to another child in the course of dispute, fight, or scuffle entered into a mutual consent. A law enforcement official who receives a report of suspected child abuse is not required to make a report to DHS if the person allegedly responsible for the child abuse is a non-perpetrator child. However, the act representing any of the following crime against the child shall be subject to the reporting requirement of the Pennsylvania Child Protective Service laws. They include rape, involuntary deviant sexual intercourse, sexual assault, aggregated indecent assault, and indecent exposure. On the other hand, a reasonable force for self-defense or the defense of another individual shall not be considered as child abuse. So let's discuss a case to check your knowledge of the law. Emily, an 11-year-old with a disability, has been coming to your office for 3 years and has always seemed settled and happy. Recently, her parents have separated and Emily has become a little withdrawn. Staff thought that this was as a result of breakup of her parents. Today, you have noticed when working on Emily that she has bruises on her arm and face. She is very withdrawn and doesn't seem to be her normal self. When you ask her what happened to cause these bruises, she becomes very tearful and doesn't want to tell you where she got them. There are 2 questions that I like to ask, and think about it. Is there a reasonable cause first to suspect Emily may be a child at risk of abuse, harm, or neglect? And then what should you do? The answers are very simple by now. According to this scenario, there is a reasonable cause to suspect. Remember, you only need reasonable cause to report the child abuse. Therefore, the answer to that question is, what should you do is you should make a report to Childline. Pennsylvania law protects all reporters of suspected child abuse. When a report is made in good faith, a reporter is immune from civil or criminal liability and cooperate with an investigation also, if necessary, to testify in proceeding. The law, however, imposes penalty if any person attempts to intimidate, retaliate, or obstruct an individual from reporting suspected child abuse. A reporter may also take action if appropriate, relief if discharged from employment or discriminated against in any other ways as a result of making a report of suspected child abuse. The reporter's name is held confidential. Only law enforcement and medical directors may assume custody of a child without a court order. Reporters are protected by a strict confidentiality provisions. Amendment to the Child Protective Service Law prohibits the department, county, institution, school, facilities, or agency or designated agent of the person in charge from identifying the person who made the report of suspected abuse or who cooperated in a subsequent investigation. So the next subject is really important. Basis for relief. A person may take action if appropriate relief if all of the following applies. The person is required or encouraged to report a suspected child abuse. The person acted in good faith in making and causing the report of suspected child abuse to be made. As a result of making the report of suspected child abuse, the person is then discharged from the employment or is discriminated against with respect to the compensation, hire, tenure, term, condition, or privilege of employment. This section does not apply to an individual making the report of suspected child abuse who is found to be a perpetrator because of the report or to any individual who fails to make a report of suspected child abuse as required and is subject conviction for failure to report or to refer. Similar to HIPAA, as a general rule, privileged communication between you as a mandated reporter and a patient or client of yours shall not apply to situations that involve child abuse and does not relieve you of your responsibility to report. Now, the following protection shall apply. Confidential communication to a clergy or an attorney, as long as they are within the scope of the law, are protected. In regard to the confidential communications, the law clarifies that confidential communication made to an attorney are protected as long as they are within the scope of the Child Protective Service Law of Pennsylvania, Consolidated Status, or section number 5916 relating to confidential communication to an attorney, and the section number 5928 relating to confidential communication to an attorney, the attorney work product doctrine, or the rules of professional conduct for attorneys. Act 54, which was adopted in 2018 regarding mandatory notification of substance exposed infant by healthcare provider states a healthcare provider shall immediately give notice or cause notice to be given to the Department of Human Services if the provider is involved in the delivery or care of a child under 1 year of age and the healthcare provider has determined based on the standard of professional practice that the child was born affected by substance use or withdrawal symptom resulting from parental drug exposure or a fetal alcohol spectrum disorder. Notification to the department can be made to Childline electronically through the Child Welfare Portal or 1-800-932-0313. This notification is for the purpose of assessing a child and the child's family for a plan of safe care and shall not constitute a child abuse report. To clarify who is considered a healthcare provider, a licensed hospital or healthcare facility, or a person who is licensed, certified, or otherwise regulated to provide healthcare services under the law of the Commonwealth of Pennsylvania, including a physician, podiatrist, optometrist, psychologist, physical therapist, certified nurse practitioner, registered nurse or nurse midwife, physician assistant, chiropractor, dentist, pharmacist, and an individual certified to provide behavioral health services. So what is the plan of safe care? After notification of a child born affected by substance use or withdrawal symptom resulted from parental drug exposure or fetal alcohol spectrum disorder, a multidisciplinary team meeting must be held prior to the child discharge from the healthcare facility. The meeting will inform an assessment of the need of the child and the child's parent and immediate caregiver to determine the most appropriate lead agency for developing and implementing as well as monitoring a plan of safe care. The child's parent and immediate caregiver must be engaged to identify the need for assess, to treat for any substance use disorder or other physical or behavioral health condition that may impact the safety, early childhood development and well-being of the child. Depending upon the need of the child and parent or caregiver, ongoing involvement of the county agency may not be required. Next subject is multidisciplinary team. For the purpose of informing the plan of safe care, multidisciplinary team may include public health agency, maternal and child health agencies, home visitation program, substance use disorder prevention and treatment providers, mental health providers as well. Also includes are the public and private children and youth agencies, early intervention and development services, courts, local educational agencies, managed care organization, and private insurer, hospital, and medical provider. What are the penalties for failure to report? Basically, they are divided into 4 sections. Number 1 is failure to report or refer. Then is the continuing course of action. Then if there are cases of multiple offenses. Finally, what is the status limitation? So let's explore these in a little bit more detail. Failure to report or refer. A mandated reporter who willfully fails to report suspected child abuse or to make a referral to the appropriate authorities commits an offense. The offense is a felony of the 3rd degree if the person or official willfully fails to report, or if the child abuse constitutes a felony of the 1st degree or higher and the person or official has direct knowledge of the nature of the abuse. An offense not otherwise specified previously is a misnomer of the 2nd degree. It must be noted that if a mandated reporter makes a report to law enforcement or appropriate county agency instead of reporting to Childline, this is not offense for failure to report as long as the report was made in good faith effort to comply with the requirement to report. The next section of the penalties for the failure to report is the continuing course of action. It means that if a person's willful failure under this section to report an individual suspect suspected of abuse continues while the person knows or has reasonable cause to report a child is being subject to child abuse by the same individual, or while the person knows or has reasonable cause to suspect that the same individual continues to have direct contact with children through the individual's employment program, activities, or services, the person commits a felony of third degree, except if the child abuse constitutes a felony of the first degree or higher. The person commits a felony of the second degree. The next section is about a person who has multiple offenses. The law defines it like this: a person who, at the time of sentencing for an offense under this section, has been convicted of a prior offense against under this section, commits a felony of the third degree, with one exception, and that is if the child abuse constitutes a felony of the first degree or higher, the penalty for the second or subsequent offense is a felony of the second degree. A statute of limitation. The statute of limitation for an offense under this section shall be either the statute of limitation for the crime committed against a minor child, or 5 years, whichever is greater. Mandatory reporter right to know. If a report was made by a mandated reporter, DHS shall notify the mandated reporter who made the report of suspected child abuse of all the following within 3 business days of the department's receipt of the result of the investigation: whether the child abuse report is founded, indicated, or unfounded. Any services provided, arranged for, or to be provided by the county agency to protect the child. Let me finish this presentation by asking a few questions to make sure that we understand everything. This is an easy true and false question. The first question is, you can only report a child abuse cases if you know for fact that a child abuse occurred. The answer to this question is false. You only need reasonable cause to report child abuse. Is this a statement true or false? You should delay in seeking medical care or dental care for an injury if you are suspicious of abuse until you report to Childline. Again, the answer to this question is also false. Knowing that you must proceed to take care of an injured person immediately is important. Please refer to the PDF document on our website under child abuse, or in the comment area of this video below for resources hyperlink at www.balasurgery.com. That's BALA surgery.com. Einstein finally said it the best: the world will not be destroyed by those who do evil, but by those who watch them without doing anything. I just want to sincerely thank you for listening to this presentation. I hope together we all can be more vigilant to identify and report suspected child abuse and neglect and save many lives. I hope that you apply what you have learned during this course to recognize element and indication of child abuse and neglect and proceed to report observed cases in your field and hopefully save a life. Thank you so much for listening.